Sandra Kowalski had been handling her mother's affairs for nearly 3 years by the time the house was ready to sell. Her mother, Eleanor, 84, had lived in that house in Akron, Ohio since 1987. She'd paid it off in 2001. She'd kept it clean, kept the taxes current, and told Sandra more than once that the house was the thing she wanted to leave behind. Not much else was left, but the house was there, and it was hers. Eleanor spent her last 26 months in a nursing facility. Medicaid covered most of it. The caseworker had walked Sandra through the application, the asset limits, all of it. The house was listed as an exempt asset. Medicaid's rules said the home didn't count against eligibility. Sandra asked about it specifically. She was told not to worry. Eleanor qualified, coverage started, and the family got through what they had to get through. After Eleanor died, Sandra did everything in order. Probated the estate, cleared the title, found a real estate agent. The house listed at $268,000. They had an offer within 3 weeks. 14 days before closing, a letter arrived from the Ohio Department of Medicaid. The state was filing a claim against Eleanor's estate for $217,400, the cost of the Medicaid-funded nursing home care her mother had received. The house, the asset that had passed every eligibility check, the asset the caseworker said not to worry about, was now the target of a mandatory federal recovery program that Sandra had never heard of, that the attorney hadn't mentioned, that the real estate agent didn't know existed. It had been running quietly since 1993. In this video, I'm going to explain exactly how that program works, who it hits, and what the legal window looks like to make sure your home doesn't end up in the same position. Because this is not a story about one family in Ohio. This plays out across every state in the country, and the people it catches are almost always the ones who did everything right. Paid off the house, kept it in their own name, assumed the hard part was over. Quick note before we go any further, I'm not a lawyer or a financial advisor, and nothing in this video is personal legal advice. What this is the briefing that helps you walk into an attorney's office already knowing the right questions. If this is territory you're in, you'll want a qualified elder law attorney who knows your specific state's rules. Every situation is different, and state law here matters enormously. If you find this useful, hit subscribe. This channel covers exactly this kind of mechanism. The rules that touch what you've already built, explained clearly and without the noise. Now let's get into it. Here is the belief most people carry into this topic, and it is completely understandable because it's the logical conclusion of everything they were told at the time. Medicaid approved the application. The caseworker reviewed the assets. The home was listed, it was checked, and it passed. Coverage started. So the thinking goes, Medicaid already looked at the house. It made its determination. That chapter is closed. Sit with that for a second, because it feels airtight. And for most of the process it is. But here is the one sentence that changes everything. Medicaid doesn't take your home while you're alive. It takes it after. That is not a technicality. That is the entire architecture of the program. While you are living in that house, or even while you're in a facility and the house sits empty, the home remains a protected, exempt asset for Medicaid eligibility purposes. The state cannot touch it. You can keep it. Your spouse can keep it. And your coverage continues. The moment you die, that exemption expires. At death, the home re-enters the picture, not as an eligibility question, but as a probate asset. And that is when the Medicaid Estate Recovery Program begins. MERP, as it's called, is the federal mechanism that allows states to file a claim against a deceased person's estate to recover what Medicaid spent on their care. The eligibility side of Medicaid and the recovery side of Medicaid are two completely separate systems. Most people only ever deal with the first one. This is the gap nobody mentions at the closing table. Not when you buy the house, and not when you file the Medicaid application. The house passes the eligibility test just fine. What it doesn't pass is the estate recovery review that comes after death. And there is one more assumption worth correcting right now because I hear this one often. Some people assume that a paid-off home is what triggers this, that if you still had a mortgage, you'd be in a different position. That's not how it works. The trigger is not the mortgage status. The trigger is receiving qualifying Medicaid long-term care services after the age of 55 and owning a home in your own name at the time of death. A mortgaged home in an otherwise qualifying estate faces the same recovery exposure. What makes the paid-off home the target in most cases is simpler than that. It's the only thing of significant value left. Medicaid's asset limits are strict, $2,000 in most states. By the time someone qualifies, the paid-off house is almost always the only asset of substance that remains. Now, that age trigger. 55. I want to come back to why that specific number is in federal law, and what it means if you're approaching it right now, because the answer is more important than most people realize. Let's start with where this program actually comes from, because understanding the source matters. The Medicaid Estate Recovery Program is not a state invention. It is not something Ohio created or California or Texas. It is a federally mandated program required by an act of Congress, the Omnibus Budget Reconciliation Act of 1993. Every state in the country is required to operate it. There is no opt-out. There is no state that looked at this and decided not to participate. If your state runs Medicaid, and they all do, your state runs a state recovery. Now, back to that number, 55. Congress set the age trigger at 55 because that is the federal floor for mandatory recovery. For anyone who received qualifying Medicaid services at age 55 or older, the state is required to seek reimbursement from the estate. Below 55, recovery is optional at the state level. Above 55, it is not. And here's the thing people miss about that ceiling. There isn't one. The federal mandate doesn't cap out at 65 or 70 or 75. If you received Medicaid long-term care services at 80, the clock started at 80. Age 55 is where the obligation begins, not where it ends. The reason Congress chose that number isn't mysterious when you look at the cost. A private room in a nursing home now runs roughly $10,978 a month. That's the current national average. A 2-year stay is not unusual. That's over $260,000 in Medicaid expenditures on a single individual. At some point, the program looks to recover those costs. The age threshold is simply where Congress drew the line between deferring to the individual and beginning that recovery process. Now, let's be precise about what services trigger mandatory recovery, because not every Medicaid expense qualifies at the federal level. The federal floor covers 3 categories. Nursing facility services, that's the standard long-term care nursing home. Home and community-based services, care provided in the home, assisted living, adult day programs, and related hospital stays and prescription drug costs connected to those services. If your loved one received Medicaid for any of those services after age 55, the estate is subject to mandatory recovery under federal law. But here is where the picture gets more complicated and where state variation becomes the dominant factor in this conversation. Roughly 2/3 of states, about 37 of them, expand their recovery programs beyond that federal floor. They recover more than the minimum requires. Some pursue a broader set of services, some pursue a broader definition of what counts as a recoverable estate. And that second part is where families get the biggest surprises. Under the basic federal framework, estate recovery applies to probate assets, the property that goes through the formal legal process of a will. But approximately 27 states use what's called an expanded estate definition. In those states, recovery can reach assets that would otherwise pass directly to heirs outside probate entirely. That includes jointly titled property with right of survivorship. It can include assets held in a basic living trust. In some states, it can reach annuity remainder payments and certain life insurance proceeds. I want to be direct about why that matters because I see this mistake made often. People hear that joint titling or a living trust protects the home, and in some states, under some circumstances, they're right. But in an expanded recovery state, that assumption can be wrong in a way that costs the family the entire asset. The strategy that works in Florida may not work in Massachusetts. The approach an attorney set up in Ohio 10 years ago may need to be revisited given how state rules have shifted. This is why the phrase, consult a qualified elder law attorney in your state, is not a disclaimer I throw in to cover myself. It is the actual operative advice. State law is doing enormous work in this area, and the difference between a protected estate and an exposed one often comes down to which state you're in and exactly how the deed is titled. So, the mechanism is clear. Federal mandate, age 55 trigger, probate, and in many states, non-probate assets, 2/3 of states expanding beyond the floor. That is the system as it runs. But federal law also built protections into it. 5 of them, and they matter, though one of them has a catch that catches families off guard more than almost anything else in this space. That's coming up next. And if you have a parent in a facility right now, or a sibling who lived at home to help a parent, you'll want to hear it carefully. Federal law did not create the Medicaid estate recovery program without limits. Congress built 5 protections into the statute, 5 circumstances under which a state cannot pursue recovery or must at minimum consider deferring it. These are not loopholes. They are part of the law as written. Let's go through all 5, because any one of them could apply to your family, and not knowing they exist is how estates get settled unnecessarily. The first protection is the one most people have heard of, at least in passing, the surviving spouse. If a Medicaid recipient dies and a spouse survives them, the state cannot pursue estate recovery while that spouse is alive. The claim is not forgiven. It is deferred. The state waits, but for the duration of the surviving spouse's life, the home is protected from recovery action. This is a meaningful protection, and for married couples where one spouse needs long-term care, it is often the primary buffer. What it is not, and this matters, is permanent. When the surviving spouse dies, the deferral ends. If the home is still in the estate at that point, recovery can resume. The protection follows the person, not the property. The second protection covers a minor child. If the Medicaid recipient is survived by a child under the age of 21, recovery is deferred for as long as that child is a minor. Given the age of the population we're talking about, people in their 70s and 80s, this protection applies less frequently. But it exists, and it should be checked. The third protection is broader than most people expect. A surviving child who is blind or permanently disabled at any age blocks estate recovery entirely. There is no age cap on this one. A 50-year-old child with a qualifying disability is as protected under this provision as a 5-year-old would be. Now we come to the fourth protection. This is the one with the catch. And it is the one I want you to listen to carefully, because it protects more families than almost any other provision in this area, and it is almost universally misunderstood. It is called the caregiver child exemption. Here's what the law says, plainly. An adult child who lived in the parent's home for at least 2 years immediately before the parent entered a nursing facility, and who provided care during that time that allowed the parent to delay or avoid institutionalization, that child may receive the home without triggering estate recovery. The transfer is recognized as outside the normal look-back rules, and the recovery claim does not attach to it in the way it would to a standard transfer. When families hear this, the instinct is to think, "That's us. My daughter moved back in. She helped. She was there." And that may be true, but here is the catch. And it is significant. It is not enough to have been present. It is not enough to have helped with groceries or driven to appointments or checked in regularly. The law requires that the care provided was the reason the parent stayed out of a facility. That is a legal standard, and it requires documentation. Medical records that show the parent needed a level of care that would otherwise have required institutionalization. A record of the care actually provided, what was done, how often, by whom. And the 2-year clock runs backward from the date of admission to the facility, not from the date of death. Families who believe they qualify for the caregiver child exemption and do not have documentation, or who moved in after the parent was already in a facility, often find that the exemption does not hold when the state reviews the claim. This is not a paperwork technicality. It is the difference between the home passing to the child who gave up years of their life to keep a parent at home and the home being liquidated to satisfy a Medicaid recovery claim. If this is your situation, or if you believe it could be, that documentation conversation needs to happen with an elder law attorney, and it needs to happen before the Medicaid application is filed, not after the parent has died. The fifth protection is the sibling exemption. A sibling who had an equity interest in the home, meaning they were a partial owner, and who lived in the home for at least 1 year before the Medicaid recipient was institutionalized, may also qualify to receive the home without triggering recovery. Both conditions must be met: equity interest and at least 1 year of residence prior to institutionalization. And beyond those 5, every state is federally required to offer what's called an undue hardship waiver. If pursuing recovery would deprive an heir of their primary residence, or if the estate is so modest that recovery would cause genuine hardship, a waiver can be requested. It is discretionary. It is not guaranteed. It requires an application and a review, but it exists in every state, and in cases where no other protection applies, it is worth exploring with an attorney. If any of these 5 protections sound like they could apply to your family, a surviving spouse, a disabled child, a sibling with equity interest, or an adult child who moved in and provided care, I'd encourage you to drop your state in the comments below. I want to see how many people watching this are actually inside one of these situations, because I think the number is larger than most people assume. And knowing which protection might apply is the first step toward doing something about it. Let's talk about what this actually costs, not in abstract terms, in the specific grounded numbers that show why a $217,000 recovery claim against a single paid-off house is not an outlier. It is, in many cases, a conservative estimate. A private room in a nursing home currently costs an average of $10,978 per month. That is the current national figure from CareScout's 2026 data. Round it to $11,000 for the math, because the precision matters less than the scale. At that rate, 1 year of nursing home care runs roughly $131,000. Not $131,000 total for a stay. $131,000 per year. Now hold that number against what a typical stay actually looks like. The average nursing home stay is not a few weeks. It is not a few months. For residents who enter a facility for long-term care rather than short-term rehabilitation, the median stay runs closer to 2 years, and many residents stay significantly longer. A 2-year stay at current rates generates roughly $260,000 in Medicaid expenditures on a single individual. A 3-year stay pushes past $390,000. Eleanor's stay was 26 months. The claim against her estate was $217,400. That math is not punitive. It is almost exactly what the care cost. And this is the part worth sitting with for a moment, because it reframes the whole picture. Medicaid is not a grant program in the way most people think of it. It is, at the long-term care level, closer to a loan secured against your estate, one that comes due after death, with the home as the primary collateral. The eligibility side of the program looks like assistance. The recovery side of the program looks like a lien. Both are part of the same system, and the second half is the one nobody explains at the application stage. The scale of this nationally confirms it is not a niche concern. In the last fully reported federal fiscal year, 2019, states collected $733.4 million through Medicaid estate recovery. That is not the total value of claims filed. That is the amount actually recovered in a single year. And the vast majority of that recovery came from estates that looked exactly like Eleanor's. A paid-off house, minimal liquid assets, and heirs who had no idea the claim was coming. Medicaid is the largest single payer for long-term care in the United States. It covers roughly 2/3 of all nursing home residents, not because 2/3 of Americans plan to use Medicaid for their care, but because the cost of long-term care is high enough and the asset limit strict enough that most people exhaust their resources and qualify before the stay is over. The program is enormous. The recovery mechanism attached to it is proportionally large. And the estates it targets are, almost by definition, estates where the home is the only thing left to recover from. That is Sandra's story. That is Eleanor's estate. And it plays out in some form in every state in the country every year. Sandra's house sold for $268,000. After the Medicaid claim was settled, she and her brother divided what remained, just over $50,000, split between two people, after a sale that took months, after a process that took years. Less than 20 cents on the dollar from a house their mother spent 35 years paying off. She told me she wasn't angry at the system, Sheets. She understood eventually that the state wasn't acting outside its authority. What she was angry about, and what she remains angry about, is that no one told her. Not the Medicaid caseworker, not the estate attorney who handled the probate, not the real estate agent who listed the house. The information existed. The law was public. The program had been running for over 30 years. And somehow, not one person whose job touched this situation had ever mentioned it. That gap between what the law says and what families actually know is exactly what this channel exists to close. So here's the question that actually matters now. If this program has been running since 1993 and the numbers are this significant, is there a legal way to protect the home before it becomes an issue? There is. But the window for it is specific, and it is not as wide as most people think. In fact, for a meaningful portion of people watching this right now, the window is already narrowing, and some may have already passed the point where the most powerful strategies are available. That is what we're covering next, and it is the most actionable part of this entire video. Everything up to this point has been about understanding the mechanism. This section is about what you can do about it legally, specifically, and before the window closes. Let's start with the constraint, because the constraint is the whole ball game. Medicaid has a 5-year look-back period. In 48 states and the District of Columbia, when someone applies for Medicaid long-term care benefits, the state reviews every asset transfer made in the 60 months prior to that application. Every gift, every transfer to a child, every deed change, every trust that was funded during that window. If a disqualifying transfer is found, meaning an asset was moved for less than fair market value during that 60-month period, the state imposes a penalty period, a period during which the applicant is ineligible for Medicaid benefits, even if they otherwise qualify. The length of the penalty is calculated by dividing the value of the transferred asset by the average monthly cost of nursing home care in that state. Transfer a $250,000 house in a state where that monthly cost is $10,000, and you may be looking at a 25-month penalty period, 25 months of no Medicaid coverage starting from the date you applied. That penalty does not begin when the transfer happened. It begins when you apply, are otherwise eligible, and are sitting in a facility that needs to be paid for. It is, in practical terms, a bill that comes due at the worst possible moment. This is the move that backfires most often, and I want to be direct about it because I hear about it constantly. A parent decides to give the house to the kids. The intention is clear. It's that they want to protect it. They want to make sure it passes to the family, and they've heard that getting it out of their name is the right move, so they do it. They sign a deed, they transfer the title, and they feel like the problem is solved. If that transfer happened less than 5 years before the Medicaid application, it is not solved. It has created a new problem, a penalty period that can delay or eliminate the coverage the family is counting on precisely when the care is needed most. The house may be gone from the estate, the Medicaid coverage may be suspended, and the family is left paying out of pocket for a facility that costs $11,000 a month while the penalty clock runs down. The 5-year look-back is not a loophole to work around. It is the governing constraint that every legitimate planning strategy has to be built around. Now, California is worth noting separately here because Medi-Cal operates on a different track. As of January 2026, California's look-back period for Medi-Cal is currently 0 months, meaning no look-back is being enforced at this moment. That is not permanent. California is in a phased transition, and the look-back is scheduled to phase in, reaching 30 months by July 2028. If you are in California, that window is real. But 30 months is still a meaningful constraint. And the rest of the country is operating at 60. Do not let California's current exception create the impression that the look-back is going away nationally. It is not. So what does a legitimate planning strategy look like, given that constraint? There are 3 approaches that elder law attorneys use most commonly in this space. None of them are guaranteed in every state. All of them require professional implementation to be effective, and all of them require being started well before the 5-year clock becomes an issue. The first is a Medicaid Asset Protection Trust, sometimes called a MAPT. This is an irrevocable trust. The homeowner transfers the property into the trust, and the trust is structured so that the home is no longer part of the owner's probate estate at death. Once the 5-year look-back period has cleared from the date of the transfer, the home is also outside the reach of Medicaid estate recovery because it is no longer an asset the Medicaid recipient owned at death. It passed into the trust, and the trust distributes it to the named beneficiaries according to its terms. The trade-off is control. Irrevocable means irrevocable. The grantor gives up the ability to sell the property, refinance it, or pull it back out of the trust without the cooperation of the beneficiaries. This is not a strategy for someone who thinks they might want to sell the house in a few years. It is a strategy for someone who knows they want to keep it in the family and is willing to give up direct control in exchange for the protection. The second approach is a life estate deed, sometimes called a ladybird deed in states that recognize that specific form. A life estate deed splits ownership of the home into 2 legal interests. The parent retains the life estate, the right to live in the home, use it, and in some deed forms, sell it during their lifetime. The remainder interest passes automatically to named beneficiaries at death, outside the probate process. In states that limit Medicaid estate recovery to probate assets, a properly structured life estate deed can protect the home from recovery because the home never enters probate. It passes directly. In expanded recovery states, the roughly 27 states that pursue non-probate assets, this protection may not hold. The state may still be able to reach the remainder interest. This is one of the clearest examples of why state law is doing the operative work here and why the same strategy produces different outcomes depending on where the home is located. The third approach applies only when the caregiver-child exemption is in play, and it works differently from the other 2. If an adult child meets the qualifications we covered earlier, lived in the home for at least 2 years immediately before institutionalization, provided documented care that delayed that institutionalization, a transfer of the home to that child may fall entirely outside the look-back rules. It is a recognized exemption, not a penalty-triggering transfer. The home passes to the qualifying child without generating a penalty period and without becoming subject to recovery. The critical point here is the same one I raised in the last section. This requires documentation assembled before the Medicaid application is filed, ideally well before. An elder law attorney can help structure that documentation and confirm whether the care provided actually meets the legal standard in your state. Here's the honest summary of where all 3 strategies land. The Medicaid Asset Protection Trust is the most comprehensive protection available for most homeowners, but it requires giving up control and starting the 5-year clock immediately. The life estate deed is simpler and preserves some flexibility, but its protection is state-dependent and may not hold in expanded recovery states. The caregiver child transfer is the most powerful option when it applies, but it applies only when the facts on the ground genuinely meet the legal standard, and manufacturing those facts after the fact is not possible. What all three have in common is timing. Every one of them requires being initiated at least 5 full years before a Medicaid application is filed. Not 5 years before death, 5 years before the application, because the look-back begins at the application date and any transfer inside that window is subject to review. If you are in your late 50s or early 60s and you own a home, 5 years is a planning horizon you have. If you are in your late 60s or early 70s and haven't started this conversation, the window is narrowing. If you are in your mid-70s or beyond and have not taken any steps, the look-back period may already be the dominant constraint on what is still possible. I am not saying this to create alarm. I'm saying it because the most common version of this story, the version Sandra lived, begins with a family that had time and didn't know they needed to use it. The program is automatic. The clock runs whether you know about it or not. And the only thing that changes the outcome is starting early enough that the math still works in your favor. If you are currently inside that 5-year window, or if you've already passed the 60-month mark and taken steps to protect your home, I'd genuinely like to know. Drop it in the comments where you are, what stage you're at, whether you've talked to an attorney. I read every one of those comments, and the patterns I see there shape what this channel covers next. Let's go back to Sandra. After the letter arrived from the Ohio Department of Medicaid, she spent 3 weeks trying to understand what had happened. She called the caseworker who had handled her mother's application. She called the attorney who had probated the estate. She called the real estate agent because she didn't know who else to call. None of them had a clear answer for her. The caseworker said estate recovery was outside her department. The attorney said he handled the probate correctly and the claim was valid. The real estate agent said she'd never seen this before. What Sandra eventually learned, through her own research, through phone calls to an elder law attorney she found independently, is that the program that filed the claim against her mother's estate was not new. It was not an error. It was not something the state had discretion to waive simply because the family hadn't known about it. It had been federal law since 1993. Ohio had been running it for over 30 years. The claim was calculated correctly, filed correctly, and settled correctly. Every professional who touched the situation had operated within their lane. Not one of them had mentioned it. The house sold for $268,000. The Medicaid claim of $217,400 was settled from the proceeds. After closing costs, after the attorney's fees for the probate, after the estate was wound down, Sandra and her brother divided what remained, a little over $50,000. Split 2 ways. Their mother had bought that house in 1987. She had made the last mortgage payment in 2001. She had lived in it for 35 years, maintained it, paid the taxes on it every year, and told her children more than once that it was the thing she wanted to leave behind. The house represented something beyond its dollar value. The proof that she had built something, paid for something, left something. What the family received from it in the end was $25,000 each. Sandra was not angry at her mother. She was not angry at Ohio. She understood once she had worked through it that the state was not acting outside its authority, that Medicaid had paid nearly $250,000 for her mother's care, and the recovery program existed precisely because that money had to come from somewhere. What she was, and what she remains, is angry that no one told her, not because someone had an obligation to volunteer it exactly, but because the information existed. The law was public. The program had been running her entire adult life, and at every stage of a process that lasted nearly 3 years. The Medicaid application, the facility stay, the death, the probate. Not one person whose professional role touched her family's situation had ever said the words Medicaid Estate Recovery Program. Hassan Way. That gap is not unique to Ohio. It is not unique to Sandra's attorney or her caseworker or her real estate agent. It is the standard experience for families navigating this because MERP sits in the space between departments, between the Medicaid eligibility office and the estate planning attorney and the probate process. And each of those professionals tends to see only their own piece of it. This channel exists in that gap, not to alarm you, not to turn a federal cost recovery program into something it isn't, but to give you the briefing that the system, as currently structured, does not reliably provide. The rules that govern what happens to a paid-off home after a Medicaid-funded stay are not hidden. They are not complicated once they're explained. They are simply not explained, not at the closing table, not at the Medicaid office, not at the attorney's office unless you know to ask. Now you know to ask. If your home is paid off, or close to it, if you or a parent is approaching 55 or already past it, the next conversation worth having is with a qualified elder law attorney in your state. Not a general estate planning attorney, though that can be a starting point. An elder law attorney who works specifically in Medicaid planning and knows how your state's recovery program operates. The strategies exist, the protections exist, but they require time to implement. And the 5-year clock does not pause while you think about it. If this video gave you something you didn't have before, a clearer picture of how this works, a name for something you'd only vaguely heard of, a reason to make a phone call you'd been putting off, share it with someone who owns a home and is in this age range. Not because the algorithm needs it, though it does, because the person most likely to be caught by this program is the person who did everything right, paid everything off, and never heard the 4 words that would have changed their planning entirely. Medicaid Estate Recovery Program, that is what this channel is here to cover. The rules that touch what you've already built explain clearly before the letter arrives. Subscribe if you want to stay ahead of it. There is more coming.